Hey guys, Abe Ovadia here. Now that House Bill 837 passed and was signed by the governor on March 24th, I wanted to talk to you and update you guys through a video. Some of you are too lazy to read. It's okay. And I wanted to explain some of the things. And we're going to do a question and answer format on the website for you guys to watch these videos because I know you have a lot of questions. So first things first, the bill was signed on 3/24. The way the law is worded for PIP-related matters, if an auto insurance policy is purchased by a driver on 3/25, that policy, there's no attorney's fees moving forward. Okay, so if somebody purchases a policy on 3/24 or 3/23 or February, January, the old law for PIP suits still applies. There's still attorney's fees. It was very clear in Section 29 of the House Bill 837 that this law only changes policies moving forward. So if a policy is purchased on March 25th or later, more recent, then there's no attorney's fees for that. The 200% Medicare fee schedule is still in place. You still need an EMC to get more than $2,500. You still, everything is the same in PIP, except there's no attorney's fees, okay? For policies that are purchased on March 25th or more recent, okay? March 26th, et cetera. Now, so for cases that are March 24th or older, March 23rd, et cetera, those cases are still attorney's fees, okay? And everything is 100% normal, and it's when the policy is purchased. So let's just give an example here. March 24th, when the governor signed it, someone purchases a policy on March 24th. They get in an accident 4 months later. There are still attorney's fees to collect the PIP money owed to the doctor. You can still do an assignment of benefits lawsuit on those cases. Let's say someone gets into an accident. Let's say someone purchases a policy on March 25th and they get into an accident the same day. No attorney's fees because it goes by when you purchase the policy. So just to be clear, it doesn't go by date of loss. It doesn't go by the day they first see a doctor. It goes by when they purchase that auto insurance policy. Section 29 of House Bill 837 is very clear. It's not retroactive. It's only for policies purchased on March 25th and moving forward, okay? Now, how does that affect the doctors, right? Everybody's like, Abe, this is about attorney's fees. No, it's not. Attorney's fees is the only thing that kept these insurance companies honest. So if there's no attorney's fees, we can still do PIP demand letters. We still actually have to do a demand letter. So we would send a demand to the insurance company. Let's say they very clearly say, hey, we owe you money, but we're not going to pay it to you. There may be some bad faith involved there. I'm not going to lie, but most likely they're going to say, we don't owe you any money. We don't feel we owe you any money, and they're not going to pay. So at the end of the day, moving forward, my office is still going to send a demand letter to the PIP insurance company. If they don't pay, there could be some bad faith implications. There could be maybe a class action that we could file on behalf of all the doctors in Florida to get them to pay. But nothing is going to force them to pay. Nothing's going to force them to be honest moving forward. Now, I also want to clarify. There is one way to get attorney's fees under the new law for policies that are purchased on March 25th or more recently. And that way is only going to affect maybe 5% of cases max. State Farm, Geico, it's not going to affect them really. They don't really do a total coverage denial. And I'm going to use the exact words here because I don't want to jumble this up under the new law. The statute says a total coverage denial of the claim. Does that mean a CPT code, a CMS 1500 form, a claim form? I don't know. Does that mean the whole case coverage? I don't know. We'll find out. But typically, coverage denial, total coverage denial is coverage. We're not going to pay anything on this case because of XYZ. So your Geicos, your State Farms, they don't really deny claims for PIP like that. your United Autos, your Ocean Harbors, Windhaven, when they were around, they denied a lot of claims for material misrepresentation, EUO no-shows, right? That would be more of what I would imagine is a total coverage denial of the claim. So if it's a total coverage denial of the claim, maybe fraud, right? The insurance company claims there's fraud. That would be, in my opinion, a total coverage denial of the claim. Then you can get attorney's fees, but only if the lawsuit is filed in the name of the insured, of the patient seeking benefits. And it has to be brought as a DEC action. That doesn't really matter to the doctors, more for the lawyers. So just to reiterate that, the lawsuit for a total coverage denial of the claim has to be brought in the name of the patient. So the doctor can't do an AOB lawsuit to collect the money that he or she may be owed. It would have to be brought in the name of the patient. Who represents the patient? Well, typically, my law firm will represent a doctor's office on behalf of, as the assignee of the patient, to collect the bills. The patient's not really involved. I don't need a retainer agreement signed by that patient. Under this law, if it's a total coverage denial of the claim, which again is really 5% of most PIP suits, I would have to have a retainer signed by the person seeking PIP coverage, the patient. I would have to have a retainer signed by them. Very unlikely that they would, a year after treating, would say, sure, I'll sign that contract with a lawyer. Like, it's not going to happen. So most likely, either the injury lawyer who's representing that client during the pendency of their injury case, they may file the PIP suit on behalf of the injured person, the patient, or they may refer that case to another attorney who specializes in PIP, who practices in PIP suits, okay? And they may, obviously get a referral fee for that referral, 25% referral fee. The doctors always hate it. They're like, why can't we get referral fees, Abe? But lawyers can get the referral fee, obviously. And so the injury lawyer will either handle it in-house or refer it to someone who specializes with PIP suits. The doctor, the medical provider, won't really be able to make that decision only for a total coverage denial of the claim to get attorney's fees, okay? So I want to be clear. The doctor can still get an assignment of benefits signed. They can even bring a lawsuit as an AOB. They can file their own lawsuit, okay? Even if it's a total coverage denial of the claim, they can file it. But they can't get attorney's fees the way this statute is written, okay? So if a doctor wants to bring an AOB lawsuit for policies that are purchased on March 25th or more recent, okay, March 26th, et cetera, there's no attorney's fees, okay? So can you bring an AOB lawsuit? Yeah. Can you get attorney's fees for it? Only if I would be representing the patient who treated, and only when there's a total coverage denial of the claim. All right. Total coverage denial of the claim definitely includes material misrepresentation claims, right? Definitely includes like an EUO no-show. Hey, we're not going to cover this claim because they didn't comply with the provisions of the policy, stuff like that. Fraud allegations, right? Does it include maybe an IME cutoff where the doctor submits a claim form and the claim is denied? That I'm not sure, okay? That I'm not sure. That would be up to the courts to decide if that's a thing. So just to reiterate, the only law that House Bill 837 kind of gutted was attorney's fees for PIP suits, and it only affects policies that are purchased after on 325 or later, okay, 326, et cetera. If a policy was purchased on 324, 323, in that direction, still going to be attorney's fees available on that case, which means the insurance company has an incentive to pay that claim properly. So hopefully that wasn't too confusing. I'm going to move on to the next topic in another video. Thanks.